Okay, we'll be recording. Okay, all right. All persons having business before the Honorable Associate Judges, now presiding over the District of Columbia Court of Appeals. Draw near and give your attention. God save the United States and this honorable court. This honorable court is now in session. Please come to order.
Good afternoon, everyone, and welcome to the District of Columbia Court of Appeals. We have one case on this afternoon's summary calendar, and that is In Re Timothy Moore, number 18 CM 1144. Ms. Beskier, whenever you're ready.
Thank you. Good afternoon, and may it please the court. My name is Cecily Beskier on behalf of Appellant Timothy Moore. I'd like to reserve 2 minutes for rebuttal. Timothy Moore did not willfully disobey the civil protection order on April 7th or April 11th because he complied with what he honestly understood the stay away restriction to be. He stayed at least 20 feet away from Ms. Kemper at the marina.
And I'm sorry to interrupt you right at the outset, but on this factual kind of threshold question, which I gather you're emboldened to say he, what his state of mind was about the violation or about the term of the CPO because of what the judge said, crediting his testimony in that regard. Can you talk to us a little bit though about whether that credibility finding survives the kind of post-verdict colloquies and orders? It seems like at some point Judge Sadler kind of backs off of that by making statements about how there was no mistake. So how do you see all of that?
So I think what the trial court did was repeatedly reaffirm the credibility findings through each of those 3 hearings, the July ruling, the August, and then the September one. And I think my best explanation for what she meant when she was saying then, well, there was no mistake, even though she didn't back off of the credibility finding, was, I think, in some of the language she used in the August hearing, she starts to talk about sleepwalking. And then there's another example later about simple assault or sort of when somebody just sort of words coming uncontrollably out of their mouth. And I think looking at how she talks about those things, and particularly the August one where she says, well, if he'd maybe been sleepwalking, that might be a mistake or accident. I think that illustrates what the trial judge was thinking that a mistake meant.
Ms. Beskier, let me ask you to focus, if you will, on her written order denying reconsideration. And I'm looking at page 109 of your appendix, just before the new subheading. I'm curious about this statement. The court is therefore satisfied that the defendant understood the contents and implications of the civil protection order when it was issued to him. That doesn't sound at all like the credibility finding that she made earlier in the case.
So, Your Honor, in the written order, she does say that, and that I believe is a plainly wrong finding in light of the evidence that is in the record and the fact that there's nowhere in the written order that she does come back from what she'd said about the credibility finding. She says, if I said anything before that isn't consistent with this order controls. But this finding that she both made in July and in the written order that, well, he understood, I'm satisfied that he understood it, that is based on her saying, well, she said, at the time of the meeting, he understood. There is no testimony in the record where he said that he understood it at the time of that January hearing. And the court on this record can't infer that knowledge or understanding just from the fact that the order was given to him in open court 10 weeks before the violations, or that it was written clearly, because she did credit his testimony that in April, he didn't understand it correctly anymore. So I think that in looking at the record and the explicitly not coming back from the factual credibility findings, that statement about I'm satisfied that he understood it, that is plainly wrong, and that can't survive scrutiny.
I
here.
suppose it's possible.
How do you explain that she said both things?
I think, unfortunately, I think the judge was somewhat confused through the proceedings. And I think part of how that comes out most clearly, or sort of trying to make sense of where the judge was, comes out most clearly right before she moves to sentencing in the August 24th transcript, when she says, well, this belief, I don't have the exact quote right in front of me, but she says, it's irrelevant what he thought at the time that he was taking these actions. The judge throughout keeps thinking, well, this is a general intent crime, and general intent means it doesn't matter what he thought. It doesn't matter if he misunderstood it at the time that he was acting. And so I think when you look at things through that lens of the judge's understanding that that's what general intent meant, these things make sense. How she could say on the one hand, I believe that he thought this in April, but it doesn't matter, he's still guilty. And I think that understanding of general intent is incorrect, and that it was actually the court's main error in this case, because, yes, Your Honor?
I can't tell who you're looking at. If you're looking at me, I suppose it's
Yeah, it
possible
looks
that
Sorry.
we get used to this over time. It's possible that she, you were saying there's no evidence that he did understand it, because the testimony he gave about understanding it was he understood it after his lawyer told him about it. But it's possible that she could discredit his testimony saying he didn't understand it. But she explicitly credited it at trial. So, and is there anything in the colloquy or the order or the sentencing where she suggests she's changing that? It would be odd to, at the time of trial, say, I credit you, I think you were telling the truth, but that doesn't matter because I'm applying this general intent. And then later on saying, I've decided I actually didn't credit you. But is there any sense that that's what she's trying to do, or it's really more of a, I don't think it matters?
My reading of the record is that it is the latter, that she just doesn't think that it mattered. And I apologize if there's a telephone ringing in the background that I was not able to.
We all think it's in our office.
Yes, I'm sorry. So I don't see anything in the record that shows that she was moving away from that belief. And she did say at the time of trial, or in her initial ruling, not only did she specifically credit his testimony, she generally credited his testimony about both of the April incidents. So there's no point anywhere where she's discredited anything that he said. She just says, well, it doesn't matter because this is general intent. And I think part of that confusion is understandable because there's an imprecision in the case law that has.
Yeah, well, I was going to ask you about that. Why isn't she right? We certainly have our share of cases saying just that.
Mm-hmm. Well, I think the cases that say that are different from this because none of them involved credited defenses that would raise a question about whether sort of the specific things that come up here. Is there an understanding of the order at the time that the violation happens? If he doesn't understand at the time that he is violating the CPO what is actually prescribed by it, then he can't have that mens rea. And those other cases don't have facts that present that kind of situation. So there was no need for the court in those other decisions to address this kind of fact pattern. But I think Williams comes the closest, the most recent Williams.
Well, can I ask you if all we have is the CPO and you don't have, he received it in court, and you don't have this kind of testimony, I don't know if it's overcoming a presumption or just, putting on the record, developing a record on his confusion or not understanding that what he did was in violation of the CPO. Does the government have to put on anything else if you don't have the kind of testimony your client gave here?
I think it wouldn't in those cases because that would look like the CPO cases this court has seen before. I think you could say that the government can make a prima facie showing that he knows and understands, or that a defendant knows and understands an order by showing it was received in open court and that it's clear and specific. And so in your kind of run-of-the-mill case where maybe there's no defense that's put forth to challenge that presumption or challenge that prima facie case, then that's enough. But once you have some testimony, especially then creditable testimony, that does raise a question and rebut that presumption of willfulness, then the burden's going to shift back to the government to point to some other specific evidence that's going to overcome this credited defense. For instance, some evidence that he didn't understand it because he was acting he was in deliberate ignorance or willfully blind to what was there. He'd purposely torn it up in the courtroom and said, I'm not ever going to read this, and I'm going to be sort of reckless or deliberate in my disregard of my obligation. But we don't have any facts like that in this record. The government didn't put on any of that evidence that would be enough to overcome his rebutting of that presumption or that prima facie case.
How do you explain, the case law calling this a general intent crime without, how does that conceptually encompass willfulness? The kind of willfulness that you think we have to find.
I think that's one of the challenges because general intent is not very precise, and this court and the Supreme Court have both talked about how just saying general intent or specific intent doesn't really help us understand what is the required mental state or what is the required mens rea. We have, through the case law, gotten more information, like it's not just general intent, it's willfully disobey. But then we have a question, well, what does willfully mean and what does it apply to? And I think that the most reasonable interpretation that the court can come up with here is that willfully disobey means not just sort of knowingly taking the steps like walking his dog on this esplanade or being at this party barge, but also having that kind of willful, knowing, reckless approach to what does the CPO itself prohibit. So if he doesn't actually understand that it prohibits it, so it's not sort of a knowing violation, like getting too close to her, and he's not acting recklessly in like, I just don't care, I'm in conscious disregard that I have an obligation to do it. If it's just a negligence, then that's not enough for general intent. And this court has said that in the past, and I think that fits here.
Counsel,
Do you think willfulness, go ahead.
I'm sorry, I just wanted to follow up on the question of general intent. My sense is that we've got sort of two strands of discussion where we talk about the elements of the crime with more specificity, where we say you have to show willful disobedience of a court order, which would indicate some sort of purpose or knowledge of the court order and then purposeful action, right? But then we've got this discussion of general intent, and I'm wondering, have you traced it back to see which came first? Did they arise kind of at the same time? Do you have a sense for us on that?
I can say that I've tried tracing it back, and it makes my head spin when I try to. And I think that we would all benefit if the court is able to clarify some of that in its decision in this court. I think that, so I guess I don't have an answer of saying which came first or not, but I think what we see is a progression of more casual use of general intent or just the word willfully without making an effort to explain what it means, And then when there's a factual situation that comes up that requires probing it a little bit more, that's when the court gets into a little bit more detail. And I think an example is that Antonio Williams case in 2012, where there's the question of the jury instruction. And so the court did address head on, what does general intent require here? Willfulness, general intent is going to require at least some predicate understanding of what is prescribed. But in that case, that was stipulated to. The other cases that just say it's general intent, so the only proof that is needed is proof that you intentionally committed the act. I think that can work as a shorthand in so many of the other cases because there isn't anything that goes to raise a question about whether that understanding was really there. So I think that line of cases, like I said, works when there's no need to probe more deeply. And then Williams helps explain, well, actually, and then some of the other cases too, Davis and In Ray Jones and Hooks, all of them are starting to show, okay, it's not just intent to commit the act. There is some understanding. You need to have gotten the order. It has to be specific. It has to be not confusing. And then this case presents, and what happens when, even if it's clear and specific and written, if 10 weeks later you have a reason, maybe a negligent reason, but you have a reason to think it's only 20 feet, so that's what you do. And
do you think willfulness requires a bad purpose to disobey the order? And let me explain a little more. In Carroll, we differentiated between knowledge and purpose. Suppose I say that, yes, the defendant has to have knowledge of what the order said, and he has to deliberately take the actions that violate the order, but he need not have the evil purpose of defying the court order. Do you think that's right or wrong?
I think, Your Honor, that it is not easy to answer because the bad purpose and the evil purpose language is another example of things that are coming up where it says one thing in one case and something different in another case. And so it's not easy, I think, to discern from the case law what we're even talking about all consistently with evil purpose or bad purpose. But I don't think
you shouldn't feel any obligation to be constantly complimentary of our decisions over the years. We seem to have a couple of themes here about we get it all mixed up.
I think, Your Honor, that the court has done the best job that it can with the facts that come up in each individual case. I think the difficulty is when you look back to, say, the Townsend case in 1938, that's talking very broadly about, in criminal law, sometimes willfully means you need a bad purpose. And sometimes it means this, and sometimes it means that. And it's a lot of broad discussion that I think is generally dicta when it's talked about, and it doesn't really help any of us understand what willfully should mean in a particular context. And so here, I think, especially when we look at the more recent cases and the more recent explication, I don't think the court has to talk about bad purpose or evil purpose. I think it is more helpful to talk in terms of knowing or purposeful or negligent or reckless.
So let me try a little harder. Assuming we can all agree that Mr. Moore knew what the order required him to refrain from doing, and that he voluntarily and without accident took actions which in fact violated that order. Is that a proof of the crime?
If those were the facts, Your Honor, under this court's case law, the answer is yes, but we don't have those facts here.
I understand.
Yes, but I mean, that is the way the court has decided its CPO cases. I think it's just that some clarification would be helpful to what does it mean when we're talking about, does he know what's in the order? When does he know? Because the trial court here didn't seem to think it mattered what he knew or what he understood at the time of the actions, and that it only mattered what was going on 10 weeks earlier. And I think it is very relevant what his mens rea is at the time, like what is actuating his conduct. Does he have that wrongful state of mind in April, regardless of what may have happened in January? Of course, here his testimony is that from the beginning in January through until April 12th, he had this misunderstanding, and that was credited by the trial court. I see that my time has expired or expired some time ago. If the court has no further questions, I would hope that I may still have 2 minutes for a rebuttal.
Thank you. Of course, we will give you some time for rebuttal since we kept you up there so long. Thanks so much. Whenever you're ready, Mr. Martorana.
Good afternoon, Your Honors, and may it please the court, John Martorana on behalf of the District of Columbia. The evidence was sufficient to support Mr. Moore's conviction because he was provided with a clear and specific protective order that he admitted at trial was clear and specific, and his intentional act of coming within the victim's home on April 7th and her home in person on April 11th was willful. To turn to what Judge Fisher was saying about willfulness and what it requires. Willfulness, as this court has noted in Jones versus Harkness, in Ray Sobin, and the Hager case, that willfulness in this context, the CPO context, is that a person charged with a legal duty knows what he or she is doing. It does not require that the person suppose they are breaking the law. And that is been repeatedly held by the court.
But
So
we're not talking about willfulness in the abstract. We're talking about willfulness modifying disobedience of a court order, right? I mean,
yes,
that is, the government agrees that that's the element that of contempt, right? You have to have willful disobedience of a court order, right? You need those things. So then,
yes.
so it's not willful action that amounts to disobedience of a court order. It's willful disobedience of the court order.
It's the willful action that constitutes a violation of the court
But that's
order,
not
yes.
how my point is, that's not how we've defined the elements of the crime, right? I'm looking at Swisher, which I think one or both of the parties cited. The elements of criminal contempt are willful disobedience of a court order. So it's not willful actions that amount to disobedience of the court order.
I
So
would invite,
that's where I struggle with your argument that, well, I guess maybe I'll take a step back. Are you saying that it doesn't matter what his understanding is?
well, yes, Your Honor, to answer that question and then to take a step back, the intentional conduct that constitutes the violation of the court order, that was said in Baugh and the case that Mr. Moore relies on, Antonio Williams, and it was also stated.
Bach comes after Swisher. So,
Right, well, Swisher's
I'm sorry, I just didn't understand. What is your yes to? Yes,
so
it does not matter what his understanding of the court order is?
Yes, it does not matter what his understanding of the court order is, because he should have known what the court order said because he was served with it. Swisher is distinguishable because that involved the BRA and the Bail Reform Act, and those are totally separate elements. And Swisher, Thompson, and Evans, all of which Mr. Moore relies on, are all distinguishable. So,
Well, but Swisher is talking about the elements of criminal contempt. It's not the elements of a BRA.
yes, ma'am. And Dixon versus the United States, which is a Supreme Court case, and Bryan versus the United States distinguishes between common law contempt and contempt in statutory provisions. And this,
Okay, but we do have a statute, right? But the statute just says violations of these CPOs shall be punishable as contempt.
yes, Your Honor. And under Section 161005F, which is a general intent crime, that is a different statutory finding or a statutory purpose than Swisher, which was BRA. As this court noted in Maldonado versus Maldonado, the purpose of the Inter-Family Offense Act is to protect the victim and not to protect the contemner who violates the protective court order. So it's a remedial provision that's different from Swisher, because Swisher was interpreting the Bail Reform Act, whereas Baugh and all of the cases that I said that only require an intentional act that violates the court order, we're all interpreting Jones versus Harkness and In re Sobin, we're all interpreting 1005 G violations. And so going to what Judge Beckwith said about the credibility finding here, I think
We
that
just stick with, I'm sorry, before we get to the, I'm
Sorry.
just curious about the law, and I guess I'm not following the distinction, and to the extent that you're saying that this has some remedial purpose. I mean, he's convicted of a crime. And we made very clear in our cases, Taylor, and I can't remember the other cases, that when you're prosecuting these crimes, right, that citizens can't prosecute other citizens for crimes, right? It's the government that has to come in and prosecute these cases as crimes. So it seems to me that in that instance, if this is a crime, it's not just some sort of injunctive relief action, that you need to have the same protections under due process that you would have for any crime, right? So that requires generally, a mens rea, an actus reus, and generally, as we said in Carroll, we don't have strict liability or negligence-based crimes. But you're saying we do, because we've said that this is general intent?
No, I'm not saying this is a strict liability crime, Your Honor. I still am saying that this is a general intent crime, but the
I just
elements.
don't know what general intent means. Are you saying that it means negligence?
No. This court said in Davis, and if I might refresh or invite the court's attention to the Davis case, which Mr. Moore relies on. In Davis, he was given this court order, and it talked about, you have to complete a class, and there was no explanation to him about what that class, what it took to get disenrolled in the class. And this court held, and I'm going to quote it. It says, "No impartial trier of fact could find beyond a reasonable doubt that Mr. Davis knew, understood, or should have known or understood his responsibilities." I'll say that again, should have known or understood his responsibilities. And right there, they're saying that any reasonable person in the situation that's faced with that court order, that CPO, would not know what was constitutionally required of him under due process. Here, the court order was clear. And to go to Judge Beckwith about the credibility finding, I can understand why the court thinks that it scaled back the credibility finding, but I think there is a way to read the credibility finding using the Davis case in a way that makes sense to the court here. And I think that's saying is exactly what the trial court said. She says, okay, I credit your belief, and might I just add, Judge Beckwith, that we're only talking about April 7th. She didn't say anything about April 11th. So on April 7th, she says, I credit what you thought the order said. And then if you look on the next page, Your Honor, it's the July 25th transcript, page 16, where she credits the testimony. And then on page 17, she says, however, right, this is where she says, it doesn't matter what your belief is because you were served with a clear and specific order in court. And that is all that is required. And the courts, since Dixon and Sobin, his understanding, Mr. Moore's understanding, was not objectively reasonable based on what that court order said. He admitted on the witness stand, the 625 transcript from pages 7 through 10, the prosecutor cross-examined him about the court order, and he was given a copy of it. And he said at that time that he understood that to mean 100 yards away from the victim and her home, and that the shared premises is the exception for 20 feet, which only included the laundry room, the mailbox, the parking lot, and the shower area. So this—
I'm sorry, was that the testimony from the trial? That was his understanding as of the time of trial?
That was his understanding when he was handed a copy of the order, and he was handed the
What were
copy
you
of,
quoting from? I'm sorry, what transcript were you quoting from? The
I'm
trial
sorry.
transcript or the transcript from the proceeding where the CPO was issued?
Yes, Your Honor. I am quoting from the trial court transcript, not the
Right.
transcript of
And
the
at that
CPO.
point, he admits, now I understand, now I've talked to my lawyer, now I've actually gotten the CPO modified. But I don't see that as an admission that he misunderstood the order, I don't see that as an admission that he understood the order from the moment he received it. And I just wanted to go back to the trial court's findings of fact. You pointed us to page 16 of the court's verdict. The court couldn't be more specific. I mean, she says, the court credits defendant's testimony regarding his understanding of the terms of the civil protection order. The court finds that on April 7th, 2018, defendant believed that the terms of the CPO required that he only be 20 feet away from Ms. Kemper and Dock C while on the Gangplank Marina property. She credits that specifically.
Yes, Your Honor. But then she goes on to say it doesn't really matter because he should have known because he was served with a clear and specific order, and him coming within the 100 feet, 100 yards of her on April 7th was enough to establish the intentional conduct. Going back to what Judge Fisher said, it does not take an evil purpose. All that required is just the knowledge, which this court has held is sufficed by service of the order in open court. If he didn't understand it, he should have understood it because it was clear and specific. And
I
his
guess I
way-
can I
don't
ask
see
you-
the part
oh,
where
sorry.
she says he should have understood it. I see where she says it just doesn't matter, but I don't even see her embracing a negligence standard. She seems to be embracing a strict liability standard.
No,
right?
I don't.
I mean, I agree with you that she says I credit you, however, but I don't see that she says you should have understood it. She just says, however, this is what the CPO says. So it just seems like, well, that, it's strict liability. You did something that the CPO says you can't do. So
No,
you're
it's
guilty.
not. I'm sorry, Judge. No,
Where
it's
does she say should have known?
well, first, it's not strict liability. And then secondly,
No, I know.
wanna-
I'm asking, where did the trial judge say should have known? Or indicate
trial
that
judge-
he was embracing a negligence standard?
Your Honor, at the beginning of my question, or at the beginning of my answer, I was framing this in terms of what Judge Beckwith was talking about, how to reconcile the credibility assessment with her actual finding and whether it's
Right,
still
but
stood.
then in answering the question, you indicated that the trial court effectively made a negligence ruling. And I'm trying to figure out where that is or whether that's not, is that not what you meant to say?
No, it's not a negligence ruling, Your Honor. And I think what she says on 16 is exactly what you read. And then I think she says, but this you should have known. And that is the standard.
Where
for
does she
Davis.
say should have known? That is my question.
She
'Cause
says,
I
however,
don't
the court
see-
knows that the order specifically states that the defendant must stay 100 yards away. So even though I credit your testimony about what you knew, you should have known that because this order was clear and specific, that it required something else. And I don't think that that's a negligence finding, Your Honor. I think that that's clear.
I
for
agree. I
Davis.
don't think it's a negligence finding either. It sounds like a strict liability finding to me.
No, Judge, I'm sorry, I respectfully disagree, but I don't think that that's a strict liability finding. And the reason why is because he was served in open court with a clear and specific order, and he engaged in the conduct that intentionally violated that order. And that you don't have to show a bad purpose there. You just have to show the intentional conduct. And that's what was done. here.
Counsel,
Yes, Your Honor.
excuse me for a minute. What you're saying reminds me of the distinction between actual knowledge and constructive knowledge. Are you saying that he had constructive knowledge of what the CPO forbade and that is enough?
I think there is a way to read Mr. Moore's testimony and the record as a whole to say that he knew But then I also think that there's definitely a way to read it to say that he should have known what was in that order. And whether you want to call that constructive knowledge, actual knowledge, I just make the distinction based on what the court said in Davis, that he should have known what the court order required, because the requirement of the order being clear and specific was given to him, and that order was clear and specific to him. And might I also suggest, Judge Fisher, that Mr. Moore actually admits that should have known is the standard. And you can find that on his brief on page 18, where he says, well, you know, I didn't know or should have known. And it's in parentheses on page 18. And so he agrees with that standard that it should have known, as he should, because that's what the court said in Davis. And so—
Wait, are you talking about the Davis that involves the DV classes? Is it?
Yes, ma'am. Yes, ma'am. And I'm talking about the last page where—
Okay, but isn't this the case where the court says the government was required to establish beyond a reasonable doubt that Davis violated the order willfully, i.e. that he had a wrongful state of mind? But wrongful state of mind means—
Wrongful state of mind, Your Honor, doesn't mean wrongful purpose like Judge Fisher was talking about. Wrongful state of mind just means that he failed to conform his conduct to what the order prescribed. And that is directly linked with constitutional notice and and that's exactly what Davis held. Davis said that—
Yeah, that sounds like a lack of state of mind.
No, I don't agree. And the reason I say that, Judge, is because in Davis, what the court was saying in Davis was anybody that read this order would not have known, and with the differing testimony of the witnesses at trial, would not have known what would have been required, how many absences the person could have missed before they were disenrolled from the class. And that's the objective standard. The court was saying no reasonable person could have read this order and been faced with these circumstances and know what was required of them. Here, that's much different because he knew, I think he knew, but he also should have known based on the standard in Davis, because he was served with a clear order that he admitted on the stand. Now I understand, but any reasonable person that read that would understand what that—
I'm not sure that Davis is a good analog, because he essentially admits that he, under the terms of the CPO, what he did was a violation.
Right.
So that seems like that eliminates the issue in Davis. Maybe I'm confused by that.
I'm sorry, Your Honor. Let me try it again. So in Davis, the order was not clear about what he was required to do to complete the class, how many absences he could have, right?
Right.
It wasn't clear. So there was no way for him to know, and there was no way we could penalize him because he should have known. Because any reasonable person looking at that wouldn't have been able to know what conduct was prescribed by the order. Here, any reasonable person looks at this order and knows that it says 100 yards away from her person or home and 20 feet away in the shared common areas, which are specifically delineated in the order. And that's why I say, like what Judge Easterly was saying, maybe at that time, but at that time, if it was clear to him at trial, it was served on him on January 19th. And if it was clear to him at trial, it was also clear to him on January 19th, because Dixon says that—
Why is that? I mean, you can imagine a circumstance, just hypothetically, right? You get the order in court, you're really riled up after being in court, and you think, okay, I'm gonna go home, I'm gonna study this, I'm gonna figure this out, and then something happens, family member dies, somebody gets sick, you get in a car accident, and you don't go home and study the order, and you don't actually acquire the knowledge. You got the piece of paper. And so you think, based on what you heard in court, you have it in your mind that this is what you're supposed to do, and you act on that constraint, which is incorrect, right? And the order is clear. and then you violate it and you go before the judge and you say, Judge, you know, you're right. I did this thing and the order is clear, but you know, this thing happened to me and I didn't study the order, and I should have, but I didn't, and I didn't know, and I was operating under this mistaken constraint. And so I did not willfully violate this order. Why isn't that a defense to willful disobedience? The court can credit you or not, can say that is the biggest load of, you know, junk. I do not believe you, right? Or the court can say, you know, I do believe you. I see that you've actually put on, you know, evidence that you were in a car accident, or this person did die, or, you know, whatever. And I believe you, and I believe that you did not willfully violate this very clear order. Why can't that be true?
Because willfulness, Your Honor, and again, I'll say Jones versus Harkness, Hager, and In re Sobin, all of those cases clearly say that all willfulness requires in the CPO context is that a person who is charged with a legal duty understands what he or she is doing. This person was
any
charged.
Of those cases deal with any sort of facts like the ones that I've posited, right? Do any of them present a situation where a defendant has actually said, yes, the order was clear, but I did not understand it, and the trial court actually credits the misunderstanding? Do any of those cases extend to this scenario?
No, they don't, Your Honor. But again, the standard is you should have known because it was a clear and specific order.
Can I ask you a hypothetical then? What if, I want to make sure I understand your position. If the CPO said, you know, there's a standard stay away from a person, and the man realizes that the person he's supposed to stay away from sometimes goes into this particular coffee shop in the neighborhood, but they both live in the same neighborhood, and that man goes into that coffee shop and then sees the person he's supposed to stay away from, and is it, you know, in under 50 yards or 100 yards or 20 feet, he's under the prohibited distance. What then? Is that a violation?
Well, yes, Your Honor, because I think what you're talking about is exactly the facts in Antonio Williams, right? He was given a stay away order in an unrelated case, and he went to the victim Flood's house on 3 different occasions. But in that case, he stipulated that he understood exactly what the order here. It's sufficient enough for Mr. Moore to have been served with that order. And I want to go back to what Judge Easterly said. Judge Easterly, the facts that you said in your hypothetical is not exactly what happened here. I mean, Mr. Moore was asked by his counsel, why didn't you read this order more closely? Why didn't you read it more closely? And he says, well, I thought 20 feet was the magic number, but yet it clearly says exactly the opposite of what he thought it said. And that means that he should have known because it was clear and specific. And so I think when we're talking about willfulness, we have to show that he was served with the order, that he had knowledge. And Dixon says, and Hooks versus the United States says, that such knowledge is often demonstrated by virtue of the fact that he was served in open court with the order, which is exactly what happened here. That order was clear and specific under Hager. It was clear and specific under federal marketing. It had the constitutionally required notice, and all that is required once that happens is just the intentional act that violates the order. What differentiates that, Judge Easterly, from the strict liability is that he actually has notice of what that legal duty is and to conform himself to that duty. And we do not want to have a policy where we don't encourage people to read court orders. I mean, he didn't read the court order. That's what his counsel said. And we do not want a defense for my domestic violence brethren at trial councils that anytime somebody's read with a court order, they can just throw it away and say, oh, I'm not culpable because I didn't read the order. So with that being said, I see my time has expired. Please affirm the trial court's finding in this case.
Thank you. Ms. Beskier, we will give you a few minutes.
Thank you very much. I'd like to start with Davis and this should have known language, because Davis does say at the very end that no trier of fact could find that he knew or understood or should have known or understood his responsibilities. There's no explanation or analysis in the case of where that should have known comes from, but I think if should have known is a standard, it has to translate at least to a level of recklessness and not just negligence. Otherwise, we're saying you either know the order or if you're negligent, like in the hypothetical Judge Easterly was offering, negligence would then be enough for somebody to be guilty. And here, Mr. Moore very well may have been negligent in not carefully reading this order, but there's no evidence in the record that he was reckless about it or intentional or deliberate about not reading it and not understanding it correctly. And I think that's a way to reconcile this language in Davis with the case law out there that negligence standards that are not explicit in a statute are disfavored in the Constitution.
Well, is Davis even talking about what the element is? I mean, I thought Davis was just talking about whether or not the order plainly gave notice. And it, you know, if you're explaining, look, the language is not clear such that you would understand or should have understood, that doesn't seem to me like an actual explication of what the mens rea element is. It's talking about the nature of the notice that you're supposed to be putting the respondent on.
I agree, Your Honor, that that it's certainly not clear in Davis that this should have known goes to mens rea, but this is a way to sort of reconcile it. Also within the Thompson case does talk about, we're not going to go to a negligence standard. We're going to have at least a recklessness standard. So whatever willfully means here as it applies to things, it doesn't mean something that is just going to be negligent. It's got to be at least something that is reckless or more than reckless.
Ms. Baskier, let me tweak a hypothetical that Mr. Martirano has used and you've used in slightly different forms. Let's assume that Mr. Moore testifies. I've been in court before. We've been talking all the time about 20 feet. I'm in court in January and they enter a new order which extends the stay away period. 20 feet is stuck in my head. I never read the written order they handed to me. Is that a sufficient record to prove willfulness?
Your Honor, it is not a sufficient record, and it is not that different from what we have here. Unless there is something more to show that he is acting knowingly, deliberately, recklessly in the not reading of the order and double checking to make sure he understood that 20-foot thing restriction correctly, it doesn't rise to the level of willfulness.
Now that's creating an awful big loophole. Let me distinguish two situations. I read it, but I just plain misunderstood it. And I think why I misunderstood it is because 20 feet was stuck in my head. That's a lot different than saying I never even bothered to read the order that was handed to me.
I
How
think
can we accept that as a defense to violation of a court order?
I think Your Honor is correct that there's a distinction. And I think the way to look at it is his lack of understanding of what is prohibited the result of reckless behavior or sort of knowing, purposeful, deliberate behavior in, I'm just not going to read it. I don't want to know what my obligation is and see if I can get out of jail that way, versus a negligent, I meant to do it and I thought I understood it correctly and the TPO said 20 feet. And so I thought the CPO just meant we're adding 100 yards if I'm outside the marina, but the 20 feet stays within the marina. And there was a lot on my mind and I was really distressed. So I think that you can recognize that distinction by requiring that his lack of understanding or lack of knowledge is the result. He can't be guilty unless it's the result of at least a conscious disregard of his obligation. And the record here doesn't support a conscious disregard of that obligation. Only a negligence where I think, unfortunately, in this pandemic, many of us realize you can be thoughtful and well-intentioned, trying to meet all of your obligations and still make some mistakes and things just slip your mind because of the stress and emotion that we're under. And I think what Mr. Moore experienced with the CPO based on his credited testimony is that he thought it was 20 feet within the marina and 100 yards outside of the marina, and that he wasn't acting recklessly in not double checking that in some way. I see that I'm out of time. I wanted to just quickly address the case law that opposing counsel mentioned about how you don't have to suppose you know that you're breaking the law. And there's no argument here that Mr. Moore needed to know that he was breaking the law of contempt or that he was violating section 16-1005F or G, but breaking the law is not the same as violating the judicial order. And he did need to know or understand, or at the least be in conscious disregard of his obligation to know that in order to be guilty. Thank you very much. Request this court will please reverse Mr. Moore's 2 criminal contempt convictions.
Thank you very much, Ms. Bisquier, and thank you, Mr. Martorana. I'm sorry we've been mispronouncing your name. Thanks for your briefs and for your arguments today, and the case will be submitted.
Thank you, Your Honor.
You're on mute, Kevin.
This honorable court is now adjourned.